It's the second day of the second month of the 16th year of the 21st century. Good evening. Wherever you are watching us from across the continent, I'm Yvonne Okwara Matole. We're glad you're with us on Bottomline East Africa today. We'll be focusing quite a bit on Kenya's Supreme Court that's coming into some disrepute with some damning allegations against a judge at the highest level of the courts in Kenya. What does that mean? Plus, all of the day's top stories from around the continent. Let's take a look at them now. A 200 million shillings bribe case that threatens the credibility of Kenya's Supreme Court. How practical is it to opt out of the Rome Statute? We seek expert opinion. Dissident Ugandan General David Sejusa faces a court-martial in Kampala. Welcome to the program. We look forward to your feedback. Please remember to use the hashtag BottomlineEA on Twitter. Let's begin right here in Kenya, where the country's Supreme Court has been on the spot following bribery allegations against one of the judges. Justice Philip Tunoi, accused of receiving a 200 million Kenya shillings bribe, appeared before the Special Tribunal of the Judicial Service Commission to defend himself. A whistleblower claims the judge received the bribe from Nairobi's Governor Evans Kidero to make a ruling in his favor. The governor has equally appeared before the probe committee. Our reporter Patrick Amimo has the details.
Nairobi Governor Dr. Evans Kidero appeared at the Supreme Court of Kenya for a date with the Special Committee of the Judiciary Service Commission investigating bribery allegations against Supreme Court Judge Philip Tunoi. In November last year, former journalist Geoffrey Kiplagat saw an affidavit claiming Kidero bribed Justice Tunoi with 200 million shillings to influence the outcome of a case filed by his gubernatorial opponent in the 2013 general elections, Ferdinand Waititu. In the affidavit prepared by lawyer Issa Mansour, Kiplagat claims he acted as a conduit in the bribery chain between the judge and Governor Kidero. The governor spent half an hour with the Judiciary Committee probing the allegations in closed-door sessions and shared his responses to the allegations.
I don't know the judge. I've seen him on TV, and the closest ever I came to him was when my case was being heard. Secondly, the Katwa Kigen, I don't know him. I mean, I've only seen him. And there's no way that I could have given out any money for the determination of my case because I had a very, very strong case.
On Saturday, lawyer Ahmed Nasir Abdullahi introduced a new twist to the scandal when he claimed through his Twitter account that the bribe money awarded to judges to rule in favor of Kidero was about 300 million shillings and not 200 million as reported earlier. Ahmed Nasir claims that 200 million shillings was for 4 judges, whereas 2 were paid separately. Kidero said Ahmed Nasir's claims are false and malicious.
Because my case was solid, that's why even some of the advocates, like Ahmed Nasir, approached me and had a meeting with me, that he wanted to be part and parcel of my team. And I asked him why. He said he thought it was a very good and a strong case, except he wanted a lot of money. He wanted 25 million, and in cash and in advance. And since I had a very competent team, there was no need, and there was no need for me to pay him. And it's only after I said no to him, and he knows the details where we met, the people who were in that meeting are still alive, is when he crossed and went to Waititu. And I'm surprised that him in particular has been prosecuting this issue in media, and I can assure you that I'm going to sue, and I'm going to sue damn great.
Lawyer Katwa Kigen also appeared before the committee to give his side of the story. Geoffrey Kiplagat says in his affidavit that Justice Tunoi received 200 million shillings bribe from Katwa Kigen. Kiplagat claims the money was in a very big brown briefcase and was given to lawyer Katwa Kigen, who handed it to Justice Tunoi. Katwa, who did not speak to the media, has dismissed the claims as false. Katwa, however, says he knows Kiplagat after he met him at his former workstation, Kas FM. Lawyer Andrew Musangi and his client Michael Njeru also appeared before the probe committee. Geoffrey Kiplagat claims Njeru telephoned him to enlist Justice Tunoi to assist achieve a favorable outcome for Governor Kidero.
The truth? Yeah. Well, the truth is there's no such thing as a bribe being given to Judge Tunoi as far as we know. And that's what we're helping them establish. But they will make a decision. Let me not preempt them.
Lawyer Issa Mansour was present and also gave his side of the story. He says though he prepared the affidavit on bribery allegations against Justice Tunoi, he has no vested interest in the matter. Justice Tunoi has accused lawyer Nasir Abdullahi, a former Judiciary Service Commission member, of involvement in the Chief Justice succession politics in the judiciary and was determined to ensure that he was kicked out of service. Tunoi says allegations that he received 200 million shillings from Katwa Kigen or anybody else is false, evil and capricious. Kenyans will be watching with keen interest to hear the verdict of the Special Committee of the Judicial Service Commission on the bribery allegations facing the judiciary. Patrick Amimo, KTN News, Nairobi.
Indeed, they will, and this has brought the highest court in the land into some serious disrepute. When we take a look at the nature of the allegations, this is something that Kenyans are gripped by. But we're about to get some analysis from lawyer Charles Kanjama, who'll be joining me shortly. But let's just get an understanding of the structure of Kenya's judicial system. The Supreme Court, which is the one in the spotlight at the moment, is the highest court in the land here in Kenya, and it has been put in place by Article 163 of Kenya's constitution. Now, this is the final arbiter and interpreter of the constitution and is deemed to be the one that asserts the supremacy and sovereignty of Kenyan people. Now, this is where it's interesting. It has the exclusive jurisdiction to hear and determine disputes relating to presidential elections, which is why many people are reading much more into these allegations against a Supreme Court justice than we think. Now, they also get to hear cases from the Court of Appeal, and all the other courts that come below it. That's the High Court, the Magistrates Court, the Qadhi's Court, the Courts Martial, and tribunals. All tribunals that are formed in the country fall under the judiciary. All of them, of course, falling under the Supreme Court. So this can hear the appeals from all of these levels of the judiciary. And the Supreme Court sits in Nairobi, and because it is the highest court in the land, all courts are bound by its decisions. Now, for it to be fully constituted, it needs 5 people sitting on the bench at any one time. Now, this Supreme Court judge bench that listened to Governor Evans Kidero's case had all 7, which is why a lot of aspersions are being cast not just on the one judge, but on all 7. So here is now the composition of those that we've been telling you about. The Supreme Court of Kenya is headed by its president, the Chief Justice, who is Willie Mutunga, and then we have his deputy, Chief Justice, Lady Justice Kalpana Rawal, who herself has a case at the court, and this is what a lot of people are calling judicial incest, and we'll tell you why in just a moment. Justice Philip Tunoi, the man at the center of those allegation claims, 200 million Kenya shillings is the bribe he's alleged to have taken. That report is coming out tomorrow. It's also comprised of Justice Professor Jackton Ojuang, who achieved a great milestone in his education just last year, graduating there, having put together a paper at the university he's been working on for 20 years now. Justice Mohammed Ibrahim also, and then we have finally Lady Justice Njoki Ndungu, who also joined the judiciary, the Supreme Court rather. Oh, there's also Dr. Smokin Wanjala. So this is what Kenya's Supreme Court looks like at the moment. So let's get analysis as to why this is such a big story in Kenya, and indeed what it portends for the war on corruption, for faith in our judicial systems, for justice and democracy. I'm joined by Charles Kanjama from our City Center studios. Charles, thanks for making the time. Let's talk a little bit about the court itself. Now, we know we had some serious attempts at putting things right within our judiciary. Did we put in place the right structures, or did we have all of these great individuals going into a judicial system that was rotten to begin with?
I think, Yvonne, if I may answer your question, we have a great bench. We have top-notch jurists. We have professor, doctor, academicians, very distinguished members of the former highest court in Kenya, the Court of Appeal. That was Justice Tunoi. We have people from civil sector, civil service, civil society, sorry. And we also have a member of the former committee of experts that drafted the constitution. We had a great composition to the bench, and I think there was an intention among Kenyans to get a fresh start. The Supreme Court would have the opportunity to revisit all the jurisprudence of the Court of Appeal, which Kenyans thought had taken a wrong turn somewhere along the line. I think the structures we put in place were reasonable structures. We had the Judicial Service Commission, to interview and ensure we get the right candidates for the job. We had the vetting board. And the vetting board, of course, had the job of vetting all previous judges and magistrates to ensure that only those who passed the test of the new constitution would transition. So I think the structures were in place, but I would like to think of the legal justice system as going beyond just the judiciary. It includes many other actors like Ethics and Anti-Corruption Commission, the Attorney General's Office, and so on. So when you look at it as a whole, as the legal justice system, definitely we still have a long way to go.
Okay, I know you're talking about a lot of the other systems that we put in place that were really good. But then, you know, there's certain aspects like the composition of the Judicial Service Commission and taking a look at its membership. You have lawyers who are representing Kenya's Law Society, who are then these people who are in the Judicial Service Commission. They're vetting judges, and then they are presenting cases before these very judges. And then there's the possibility, because this is the administrative sort of disciplinary commission, or committee, if you like, then just saying that there's a lot of conflict of interest. So, Charles, did we pick best practice from around the world, specifically when you take a look at some of these conflicts of interest?
I think Kenya's Judicial Service Commission is a product of a lot of comparative analysis. We've looked at Judicial Service Commission in South Africa, in United Kingdom, in our neighboring countries. We've looked at how other countries have done this thing, including India. And we got a very good mix between judges. Actually, of the 11 commissioners, 5 are judges, representing respectively the Supreme Court, the Court of Appeal, the High Court, the magistrates, and the Chief Justice himself. Those are 5 judges. We have 2 members representing the legal profession, representatives of the legal profession. We have 2 people representing the general public. The Attorney General is there, someone representing the Public Service Commission who are in charge of the public service. A very good mix of members of the Judicial Service Commission. If anything has gone wrong, definitely it's not in the structure. Some people are claiming or saying that the lawyers who represent the legal profession should not be active practitioners because there could be conflict of interest, and that is an issue that needs to be studied further. But as far as the structure is concerned, I think we have the best we could have done in 2010.
All right, so Charles, if I hear you correct, you're saying the structures were in place and we certainly got the best people we possibly could. So how did we get here? How did we get to a point where Kenya's judicial system is now being nailed on the cross? Many people saying whether the allegations are proven true or false, that Kenya's judicial system, its democracy and, you know, access to justice is now really at a crossroads. So if I gather what you're saying, we did the right thing, but yet we find ourselves in this circumstance.
Yvonne, if I may use an analogy as I answer your question. In the year 2000, in the American elections between Bush and Gore, when there was a very narrow margin between the 2 candidates, that is when really the American electoral system was tested. And it was found to be strong enough to withstand the challenges of a very close election. When in 2007-08 we had a close margin in Kenya's election, the electoral system was tested and it was found wanting. What I would like to say is that it's only in moments of crisis that you can test the strength of the structures. And indeed, I think the structures were built for a test such as this, where you have even claims of corruption against the top judges. If indeed the judiciary is able to go through this process and come out stronger, show transparency and accountability, show due process, show that it is able to comply with the values of the new constitution, even when its own members are under test, then indeed that will be the proof that we have built an institution that can last. So I wouldn't want to start mourning and saying that Kenya's judiciary clearly is not built for purpose. Now is when we'll see whether it's built for purpose. Can the Judicial Service Commission credibly investigate claims of corruption against a top judge? Can Kenyans be comfortable with the process and the result? Can the judge himself feel that he's been given a hearing? So this is the moment we are waiting for. We need to look at what is going on without prejudging the process, without jumping to conclusions. Indeed, if the process ends up above board, then we'll all say that we are confident we have a judiciary that can monitor and test itself.